I'm Maura Black, a managing attorney at Chisholm, Kilpatrick, the largest veterans law firm in the United States. And I want to talk to you today about the unaccredited claims consulting industry that has arisen in the last few years. We're in the midst of a complex period for veterans benefits. VA is still struggling to overcome its backlogs. The claims process remains persistently complicated, and many veterans are not getting the benefits that they deserve. At the same time, demand for VA benefits has increased. In 2022, Congress passed the PACT Act, which created many new presumptive conditions for veterans exposed to toxic substances during their service. VA delivered over $1.85 billion in PACT Act-related benefits in just the first year after its passage. As a result of these factors, there has been a surge of unofficial and unregulated claims consultants stepping into the VA benefit space. There are laws that prohibit charging fees for claims assistance, but these unaccredited consultants argue that the laws are not meant to regulate what they do. And since a 2006 law repealed penalties for unaccredited assistance, VA has been unwilling to challenge them in court. Currently, there are at least 60 such organizations. So what are these entities and how do their actions align with the law? We thought now would be a good moment to take a closer look at the laws that apply to accredited agents. Title 38 of the U.S. Code at Section 5901A is the prohibition against acting as a claims agent or attorney. The law states in part that no individual may act as an agent or attorney in the preparation, presentation, or prosecution of any claim under the laws administered by the Secretary, unless such an individual has been recognized for such purposes by the Secretary. So how does one become recognized for VA purposes? The standards for recognition by VA are set forth in Title 38 of the U.S. Code at Section 5904A and state that the person must be of good moral character and in good repute, qualified to render claimants valuable service, and otherwise competent to assist claimants in presenting claims. To become an accredited agent, one even has to pass a test. Title 38 of the U.S. Code at Section 5904C1 is the recognition of agents and attorneys generally. It states in part that a fee may not be charged, allowed, or paid for services of agents and attorneys with respect to services provided before the date on which a claimant is provided notice of the agency of original jurisdiction's initial decision. Unaccredited claims consultants argue that these rules do not apply to them because they are not acting as agents or attorneys. These individuals or organizations typically call themselves consultants, or a similar term, framing their role as more along the lines of coaching or assisting with administrative tasks. There are currently 6 class action lawsuits against unaccredited claims entities, each pursuing different theories. In early 2023, bipartisan groups in the Senate and House of Representatives introduced the Governing Unaccredited Representatives Defrauding VA Benefits Act of 2023, otherwise known as the GUARD Act. These bills, Senate 740 and House of Representatives 1139, would amend Title 38 of the U.S. Code to reinstate criminal penalties for persons charging veterans unauthorized fees in relation to claims for benefits. The Senate bill has 50 co-sponsors, and the House bill has 201. The bills have received significant public support, including a 2023 letter signed by 44 of the state's attorneys general. If this legislation passes, it would, of course, be game-changing. Ultimately, veterans need to get the compensation they deserve, and as soon as they need it. This is the goal that unites all of us in advocacy for veterans. To that end, we recommend that all veterans ensure that they're represented by accredited agents, attorneys, or veteran service organizations. You can check the link in the description to see if your representative is accredited by the VA.